Hey everybody, Matt Barton here with this week's Broker Minute or Two. Hope your week is going well. Had a good round of sales meetings. Thank you for everybody participating. Those that weren't able to make it, we sure hope to catch you next time. Also, just a quick heads up, we will be doing a incredible seminar on November 20th, which is on in investment, incorporating an investment strategy in as a leg of the stool of your business. Stephen Bond is putting this on. I've attended it previously. It is rock solid information. So November 20th, reserve some time. I'm not 100% sure on the time, but it is in fact November 20th. Okay, having said that, I, as a broker for almost 2 decades, get to deal with a lot of different contract issues. And what I want to talk about today is the REPC. It revolves around earnest money to a certain degree, but it could just be the contract in general, whether a contract is still in play, or here's the scenario. I'm going to use earnest money as an example, but it's not the only one. If somebody didn't deliver earnest money on time, the seller's agent, the seller themselves became aware of it, and didn't immediately or in a reasonable period of time act on either making it right or canceling the contract and using one of the remedies in Section 16, does their lack of inaction constitute agreement that that term no longer applied? You could say this a lot of different ways, but I hope you get the concept. A lot of times when I talk to other brokers, I hear terms like, oh, according to the principle of continuance of contract, or equitable estoppel, or the doctrine of waiver. I mean, there's a lot of different labels that people use, and they're using it because they know their client or the contract itself that their client wants to continue to be active is in jeopardy. And they're trying to find a reason, a rationale, an excuse to tell the seller, well, you didn't act on that, so you don't get to come back, and use that as an option to then at some later time cancel the contract because of something we didn't perform on in the past. So listen, the first thing I'm going to say by way of disclosure is there's no 100% answer on here, other than here's the 100% part. If you, your client, the other broker, the other agent want to play this game, I would strongly suggest you put your big kid pants on, because you're probably going to end up in court. And if you're cavalier enough to be like, yep, let's go to court, one thing it tells me is you've probably never been to court before, because any good attorney will tell you, let's do everything we can do to avoid going to court. Why? It's long, it's expensive, it has a huge opportunity cost, it's stressful. And when you stack all those things up versus coming to an agreement in real time versus going that route, it's obvious what the answer is. We should be pursuing an agreement today rather than trying to go into the world of theory backed up by huge expenses to be proven we were right, but losing in the process. Am I making sense here? Okay, but specifically to this issue, and I will also say this, the amount of time that elapses does have some weight on this, but I'm going to share with you something specifically about our REPC, and it's discussions I've had with other attorneys, other brokers, but I also, to quickly prep for this, utilized some summary stuff from ChatGPT about Utah law, specifically about the REPC, and in regards to, in this case specifically, earnest money. Here are 3 quick points, right? 1, Utah defines waiver, or any of those other terms we talked about, as an intentional relinquishment of a right? It can be shown by conduct, but courts do not lightly find it find it, especially if the contract has a no waiver clause. So first thing people are gonna be like, well, our REPC doesn't have a no waiver clause. Well, that's a general term they use. So for instance, in our REPC, the time is of the essence is functionally a no waiver clause. So coming back to this point is you can make this waiver issue unless there is a no waiver clause. So specifically, time is of the essence says, hey, by the way, everybody involved, dates are important in this contract and they have consequences. There is no specific requirement that the non-defaulting party respond to the default within 24 hours, 48 hours, 72 hours. There is no time requirement. So now all of a sudden we're in this gray area of like, what is a reasonable period of time? Let me just give you a quick hypothetical on this. If the requirement, according to Utah law and case law, is that the person who is losing the earnest money or falling out of contract, right, by their previous actions, some period of time in the past, they would have to prove that the seller intentionally waived, right? So this is just one of many scenarios. If I was an attorney, which I'm not, on the other side, it would be very easy for me to say, my client didn't intentionally waive. They were really busy. They had a wedding. They had a death in the family. They were on vacation in Kauai. Just because they didn't respond does not constitute them intentionally waiving their right at a remedy. When we became aware, that there wouldn't be a viable path for remedy, that's when we chose to exercise our right to cancel the contract and exercise our options for remedy in Section 16. So I just wanted to tell you that there's some portion of our industry population that hear one or two cute legal phrases and they want to act like there's some definitive attorney. If you've been around enough attorneys, they don't even agree on what some of these things mean. And so we're left to go back to kind of case law and what is established to give us an idea of how the courts probably would weigh in on this. So the last comment on this is, if your strategy is to go to court to figure out if you're right, we should have a chat. That is a horrible strategy. So the other thing I would say is, if you're in one of these situations, if earnest money doesn't get turned in, make sure you document that you've let the other side know. If you are on the other side, you need to tell your client, hey, we should probably decide pretty quickly if we're going to make an adjustment to the contract to keep it under contract, or if we're going to exercise one of our options in the remedy and cancel the contract. The one sure path to disputes and potentially litigation is ambiguity and not having a paper trail. So that's why we as a company, through our office managers, through our brokers, are always going to strongly advocate for, I don't care if you had a phone conversation. I think you need to, at a minimum, have a text, an email, better yet, whatever is agreed to as an addendum to whatever document is in place signed by the parties that are impacted. So that is your broker minute tip for the week. Hope that doesn't become your situation, but if it does, now you know how to act, and I hope you have a great week.